Hello everyone and welcome to the Black Barristers Network event, Making and Receiving Complaints, where you will receive advice from an expert panel on how to deal with bullying, harassment and discrimination. My name is Natasha Shatunde and I'm the co-founder and chair of the Black Barristers Network. BBN was launched in 2019 to promote the growth of Black barristers through providing support, visibility and community outreach. We have held some incredible events, published an important survey, and we have run some exciting projects. Further information about the Black Barristers Network can be found on our website, blackbarristersnetwork.org.uk. We have some exciting plans for this year, including the launch of a membership scheme, so watch this space. BBN has recently obtained a key sponsor, the Advocacy Podcast. The Advocacy Podcast is a podcast in which some of the best trial lawyers from around the world are interviewed about what makes them excel and what practical steps we can take to improve courtroom advocacy. The podcast can be accessed from all popular podcasting platforms. BBN are looking for more sponsors as we want to bring bigger and more exciting events and projects to you. If you would like to be a sponsor or make a donation to BBN, please do drop us an email at info@blackbarristersnetwork.org.uk or use the contact us page on our website. In 2020, BBN published a survey into the experiences of Black self-employed barristers, which revealed that a number of Black barristers have experienced inappropriate treatment, such as bullying and harassment in the legal profession, where they felt that it may be related to their race. This includes in chambers, by opponents, by judges, and others. Most shockingly, 54% felt that they were treated inappropriately by opponents because of their race at some point, and a whopping 86% of respondents felt that their experiences before judges, magistrates, and tribunals may have been negatively affected by race. Similarly, the Black Barristers Working Lives survey revealed that 53% of Black barristers have personally experienced bullying, harassment, and discrimination at work, compared to 26% of white respondents. Furthermore, the same survey showed that Black and Asian women were 4 times more likely to experience bullying and harassment at work than white men. On the topic of receiving complaints, the BSB Complaints Diversity Analysis, published in July 2021, revealed that barristers from minority ethnic backgrounds were 1.7 times more likely to be the subject of an internal complaint compared to white barristers from January 2015 to October 2019. And the same report revealed that there may be an association between being a minority ethnic background and having your complaint referred to for disciplinary action. Given these statistics, BBN wanted to equip barristers with the knowledge on what to do when seeing or experiencing bullying, harassment, and discrimination, and what happens when you are subject to a complaint through our regulator. We have a stellar panel tonight, including Elaine Banton, who is a barrister at 7 Bedford Row, who is the co-chair of the Bar Council's Equality, Diversity, and Social Mobility Committee, and who also sits on the Race Working Group. We also have Sam Mercer, who I literally just popped onto the screen. She came at the right time. Head of Diversity and Inclusion and Corporate Social Responsibility at the Bar Council, who is responsible for the design and delivery of equality, diversity and inclusion support. We have Mark Neal, the Director General at the Bar Standards Board. We also have James Wakefield from the Council from the Inns of Court Director, and also the Bar Tribunals and Adjudicatory Service Registrar. And we also have Adriana Foley at the BSB, who will also be providing us with some excellent information and advice. We'll start with some short presentations by each of the panel members, followed by a Q&A session. And thank you to all of those of you who've sent questions in advance. They'll be asked during the webinar. If you have any questions that you want to ask tonight, then please use the chat function on YouTube, which is being monitored for your questions. We'll first start with Elaine Banton and Sam Mercer, who'll be giving us information about the types of bullying, harassment, and discrimination that barristers face, avenues for support, and avenues to make complaints other than the BSB. Elaine, if you would like to start.
Mute. Yes. So the types of bullying and harassment. So what we're trying to do is ensure that people are treated with dignity and respect. So if something is belittling or demeaning, that's going along the lines of harassment. But also there's specific types of behaviours that we want to address. For example, ridicule or demeaning language. Now this can be obviously any of these can be by other barristers, or they could be people working in courts, they could be clients, or they could be judges. So ridicule, demeaning language, overbearing supervision, undermining of work output, or constant unproductive criticism misuse of power or position, being deliberately given too much or too little work, exclusion or victimization, malicious rumours, unfounded threats, being blocked or prevented from promotion or training. And obviously it can get more serious where we're talking about touching or violence, or incidents on social media, such as exclusion, or WhatsApp groups, comments being made publicly, which are also going to cause offence or be potentially discriminatory or harassing in that belittling or demeaning sense. And of course, things to do with protected characteristics. So comments that are sexist, racist, discriminatory on other protected grounds, such as against disabilities, anything like that as well is going to fall foul of what we might consider bullying, harassment, or discrimination.
I was just going to add that really there's been a huge debate. So we've been looking at bullying and harassment and inappropriate behaviours at the committee, and we've got a specific working group on it at the moment. There's a real debate about defining or not defining these behaviours, where we're worried that if we do define them, then the discussion and the focus becomes about whether somebody did behave in that way or not, rather than the impact of that behaviour. But then at the same time, there's a very strong argument that if we don't define these sorts of behaviours, then people don't really know whether it's happened to them or not. So at the moment, we're falling more in the school of thought that it's better to list examples of types of behaviour, just so that people can really identify, actually, the reason I felt that way is because this behaviour was wrong, and it is about how I've been treated. So there's lots of different sources of lists of types of behaviour. So there's some Bar Council guidance on inappropriate behaviours. There's lots of information around bullying on the Wellbeing at the Bar website, and I'll put all these links into the chat, Natasha, if people would find it helpful. And there's kind of behaviours of examples of bullying, examples of harassment, and examples that perhaps don't meet either of those criteria, but still leave somebody feeling belittled.
Thank you for that. That's really helpful. I was going to ask a question actually. So you've picked up on something that's really interesting, and I think particularly for me as a practicing barrister, it's something that I struggle with, knowing whether a particular happening towards me is something that is complaint worthy or not. Is there any avenues of support that we can go to be able to find that out?
Well, you can certainly call me up at the Bar Council. So obviously the Bar Council has a number of routes for people to kind of report in behaviour that they're uncomfortable about. First of all, there's the helpline, which is completely confidential. So anybody can call the helpline. They will end up speaking to me. And I think sometimes there's a sense of people don't want to call Bar Council because they're not sure who's going to be on the end of the phone. So it's me or a member of my team. And they can discuss in complete confidence their experience or what's happened to them. And we can work through the kind of whether that was appropriate or not appropriate in the circumstances. There's also obviously the Talk to Spot, which I hope people joining the call will be aware of, the Talk to Spot platform that we've created. And that's anonymous reporting. And it really is anonymous. I have absolutely no idea on somebody who makes the report that comes through to Bar Council. But what I can do is correspond with them through the platform and ask them questions. And so we can explore the issue. And if they feel confident, they can also call in and talk to us about it. But I think the really difficult thing about all of this is context. And it's because the same behavior between two people of a similar seniority may not be bullying or harassing or inappropriate, but where there is a power imbalance in the relationship, then it's hugely problematic. And I think that's why judicial bullying is such an issue, and the behavior of judges is such an issue. And obviously it's an incredibly hierarchical profession, and power imbalances in chambers have similar impact, as do in fact relationships with some solicitors. So I think one of the reasons why we have such a problem at the bar is the structure, the very nature of the bar, and how we work, and the scenarios and the situations in which we work. But absolutely, you can call Bar Council, and you can call me and my team in confidence to discuss this, or indeed members of the Equality and Diversity Committee who support the helpline as well. I read we've got some guidance that we're going to pull out, and it's specifically around harassment, but there's actually a lot more that we can pull out and use with respect to bullying. And it's kind of a rule of thumb, and I think it's a really good rule of thumb as to whether a behavior is appropriate or not. It's, you know, would you say this to somebody who was more senior to you, to somebody who was a different gender to you, to somebody who was a different to the same sex as you, the same gender as you, the same age as you, the same seniority? If you wouldn't say that to somebody, then I would guess that actually that should be a warning bell, that this isn't something that you should be saying. Would you want somebody to speak to a member of your family in the way in which you are speaking or have been spoken to? And I think actually they're really good ideas as a rule of thumb for starting to think about when something's crossed the line.
That sounds really good. Can we just hone in on Talk to Spot for a moment? Because I know that a number of people have heard of it, but may not necessarily know much about it. If you could just give us an overview of what it is, and then tell us how we use it, what it asks us, where the information goes, who looks at it, those sorts of things.
Yeah, absolutely. So Talk to Spot is a platform that was developed for organizations to use to investigate bullying and harassment. And Bar Council has a contract with this third-party supplier. They have it's completely based on artificial intelligence. So when somebody goes to Talk to Spot, they're not speaking to a human, they're speaking to a bot, for want of a better word, their answers will prompt questions. So you will go on to you click on to Talk to Spot, and it will give you two options to start with. The first thing that you can do with Talk to Spot is you can make a record of an incident, and Talk to Spot will send it back to you. So you've got a PDF date-stamped record of an incident. And at that point, you don't actually have to submit it to anybody or share it with anybody, but it means that you've got a record of the incident that happened perhaps, you know, sort of earlier that day or the day before. And it enables you to have a record that you can decide what to do with at a later date. I do not see that record. Only you, as the person who has created that record, will see that record. If you choose to submit and make a report to Bar Council, then that record you've made will go through to Bar Council, and it goes through to me. It only goes through to me and one other member of my team. And we've got special security access so that we're the only people who see those reports. Even when we do see those reports, we cannot see who made the report. We will only see the detail of the report. And if we want to ask follow-up questions, we do so through the platform. And again, when the individual reports answers those questions, again, we can't contact that individual directly. We have no idea on anything about the individual unless they disclose. So sometimes people will disclose their names. Sometimes people will disclose the names of the person who's behaved inappropriately towards them. Sometimes people will make records and reports on the basis of being a witness, so it hasn't actually happened to them, and that's also possible. And then what I do with all these records is I will ask anybody who makes, say, a report to me, whether they want me or Bar Council to take further action. And that could be, do they want us to raise this with somebody within the judiciary, or do they want to raise this with somebody at the bar? And we will always seek permission from the person who made the report if they do want us to take it forward and to pursue it. But obviously it's an anonymous report, and really Bar Council is not the body that can do anything with it. All we can do is advise. So for example, we might advise to report to the BSB if it was about a barrister. We might advise to report to the JCIO if it was about a judge, or the Solicitors Regulation Authority if it was about the solicitor. But we will basically wrap our arms around anybody who makes a report and give whatever advice and support they want. But they remain in control. That we cannot and will not take it any further without their permission, and we're certainly not the body that would investigate. That is the Bar Standards Board, and I'm sure Mark is sighing in relief that I'm making that absolutely clear. So we're very much the informal advice, discussion, safe place. But the other thing that's a real advantage of Talk to Spot is it does enable me to build up a picture of the types of behaviours that are occurring across the bar. Because people are using it, people do feel safe to use it as a platform. It helps me identify what are the sorts of issues that are coming up. Where should I have worries? Are certain judges' names coming up multiple times? And therefore, should we be looking at certain judges in certain court centres? Is an individual barrister's name coming up on multiple occasions? And we will always adapt our advice and any exchanges that we have with people who are making a report to kind of say, you know, this has come up before, etc., etc. So, but as I say, we can't take action. We can just advise. But the data that we get, we can use to inform training, and we can use to make our point, I guess, to the judiciary and others where behaviours are inappropriate and how they're manifesting themselves. Sorry, that was a bit of a garble, but I hope that explains Spot a bit.
That's super helpful. One of the questions that we had in advance of today's event was, when you report an incident, you are asked via Talk to Spot, what would you like the Bar Council to do about the incident? What options do we have?
Well, the options are that they're varied. I mean, from a Bar Council perspective, we can informally raise an issue, for example, if it's a judicial behaviour, with the presiding judge or a senior judge in a court centre. If it is, quite often what people want to do is they want to make a record of an incident so that it is incorporated into training, so that we have examples of the sorts of things that we would expect judges to take into account or to learn. So, for example, when I've met the judiciary before, I've been able to kind of take aggregated reports and say, these are the types of behaviours that judges are displaying, and these are the sorts of areas that judges need more training on so that they are treating counsel better. So it's limited action. If they want to pursue a formal complaint, they would need to go via the BSB or the JCIO. But we can certainly use informal channels to take action if they wish.
And while we're on the subject of judicial complaints, how does one make a complaint against a judge?
Well, I'll go on to sort of JCIO is obviously the formal body for complaints on from the judiciary, and again I'll put a link in the chat after I've stopped speaking. For that, you need to make a complaint within 3 months. The JCIO say don't wait until the end of a case before making a complaint. When I've asked them what happens when you make a complaint, and there are details on how to make a complaint and a form to fill in on their website. When I've asked what happens, they will make inquiries. They will often listen to recordings. When I've asked further questions about what then happens and how often that has actually translated into sanctions against a judge, I'm afraid it's very rare. Because one of the problems in listening to just listening to recordings is that you don't get the eye rolls and the kind of the stares and all the sorts of kind of the physical behaviors, and you know, it can be very dry if you're just looking at a transcript, or just listening. I mean, transcript's the worst, but obviously just listening to a recording doesn't always give the kind of the context and the kind of what everything else has been going on. And I think that is a flaw and a problem with the process. I think something would probably have to be really, really, really bad to get through a JCIO complaint. And I do think that there need to be more effective informal channels and a more effective process for JCIO to take it forward, because I'm not sure it's solving the problem at the moment.
Okay, so one of the advanced questions that we got was, how does one raise a complaint against a judge for ongoing judicial bullying during the currency of an ongoing trial? And I guess from what you've said a moment ago, the JCIO are saying, don't wait until the end of that trial. You can make the complaint during that. Is that correct?
Yes, that's right. But I think most, from my experience speaking to counsel, most would be too concerned about the impact that it might have on the case and on their client. And so this is why we're in the situation we're in now, where very few people make complaints and very little is actually done about poor behaviour by judges.
It's very, very tricky. If we could go back towards barristers for a moment, I wanted to discuss between you and Elaine the avenues of which we can make complaints which are other than the BSB, because we're going to come on to that in a moment. So, for example, chambers, because of course chambers should all have complaints procedures. I was just wondering if Elaine could talk to us a bit about that.
Absolutely. So chambers should all have clear, transparent procedures for internal reporting of complaints, which could be bullying or harassment, so that could be dealt with internally and informally, as well as a formal process. And so, for example, there should be an EDO or two EDOs that you could speak to about it initially to see what you wanted to do, or what the sort of state of play was. And it's really vitally important that those policies and procedures are in place, so that there is an opportunity to decide what's best to do, because you may think, for example, that there is an issue, and in fact maybe it's not, or maybe you do want to take it formally to the Bar Standards Board, or not. It may depend on the particular circumstances of the conduct in question. So having that clear, defined policy within chambers is actually really important, and it needs to be signposted. So it needs to exist, but members of chambers need to know where it is, where to find it, and, as I say, how to find the equality and diversity officers, the EDOs, who are responsible, who are potentially your first port of call with your concern. You need to know who these individuals are. And some chambers are a lot better at making that all very clear than others, unfortunately. So that everyone is meant to have those policies in place within chambers.
And I may be asking what feels like a simple question, but I really want to make things clear for everybody who's watching. If, for example, I wanted to make a complaint against a barrister who was not in my chambers, could I make a complaint to their chambers?
Sam, do you want to take that one? I'm not quite sure.
Yes, I would see no reason why you couldn't do that.
I have an interesting question. I've now just turned into a question and answer session with Natasha, but this has popped into my head. If you're making a complaint about a barrister to a chamber, so either your own or the other chambers, would the chambers or the individual barristers within that chamber dealing with that complaint have an obligation to report that complaint to the Bar Standards Board if, for example, it was serious misconduct?
My view, obviously, is that if something is serious misconduct, then it must be reported to the Bar Standards Board. And I think that the advice that we give is that you either self-report if there's a finding of serious misconduct against you, or you would have whoever led the process of the investigation would be under a duty to report the serious misconduct. That would be my interpretation of the rules.
Shall I come in on that one, Natasha?
Yes,
I very much agree with Sam. Barristers are under a positive duty to report bullying and harassment where they become aware of it or an allegation of bullying and harassment. So if a barrister in another chambers became aware of such an allegation, he or she would be under a duty to report it to the Bar Standards Board.
And perhaps this is a question for Chambers. Would they be under a duty to report it as soon as they find out? So before, for example, they've gone through their own internal complaints procedure?
Do you want to go first, Mark?
My answer would be yes, Natasha. There shouldn't be a delay in reporting it. We would expect that to be reported to us and not, deferred until a process had been followed.
I was going to say the exact wording is reasonable belief. So I think there is a short opportunity to conduct a swift investigation, and if you do determine there's a reasonable belief that serious misconduct has occurred, then the reporting obligations kick in. But I think it could be legitimate to do a short investigation first. I mean, it depends on the complaint and the level. The problem with most of this stuff is that if it's really, really bad, it's very clear what you do. It's very clear that there is a report, serious misconduct has occurred and the reporting obligation has kicked in. In most cases, there's a huge level of doubt and debate. It's very borderline as to whether a behavior has tipped into something that might constitute serious misconduct, has met, harassment or bullying, and context has to be considered within that. So I think that's where there's a little bit of a grey area. I've got more grey than Mark, who's black and white.
Other experiences that barristers, and in particular black barristers, have faced is negative treatment by court staff. So I was wondering if you could, any of you panel members, perhaps maybe Sam, could give us some information about how we would be able to make a complaint against court staff.
Well, certainly my experience so far has been where barristers have got a complaint against court staff and they have let Bar Counsel know. We have raised it with HMCTS and they have taken action and reported back. So I can only encourage barristers to let us know of any and all circumstances, so that we, once we have the information, we have very good open lines of communication with HMCTS, and we're more than happy to take that forward on their behalf. I mean, naturally, you could complain directly, but the offer of Bar Counsel support in making a complaint is there.
I was just, before moving on to Mark Neal, thinking, is there anyone else that one might want to make a complaint about? And one that I hadn't even raised before this talk tonight was clerks. If you wanted to make a complaint against our clerks, where do we go? Who do we speak to? Would we want to? That's the second question that I guess us as individuals would have to determine. But does anyone have any ideas about that? Elaine, would you like to consider, or James, maybe you had a hand up?
Yeah, just to comment that anybody who wants to make a complaint about any people in the clerks or another barrister is always placed in a difficult dilemma, and there's that fear: am I going to make matters worse? Am I just putting myself in an even more difficult situation? And everybody empathizes with that. But as I'm getting much and much older, I'd have to say my experience is that if you don't complain, you kind of make matters worse by your silence, that the behavior rumbles on. And whereas if you do complain, it's not that it's a short-term pain. I don't want to underestimate the difficulty can be, but really encourage people that in the end, it's a better thing to do, that in the end, you will respect yourself and others will respect yourself for it. And I don't want to undermine how difficult it is. But again, most chambers should have a policy about how you complain about the team, the staff team. And I would encourage somebody to talk to one of their colleagues in chambers to just first and sort of just chew it over with them. I'm having this difficulty with the clerk. What would you recommend? And you'll know somebody within your chambers who is more senior than you that you can relate to and talk it through with them. So yeah, don't suffer in silence. It won't pay off in the end, would be my view.
Can I just add, I think it's really important that people remember that kind of, victimization and the protection that you have when you make a complaint. If you suffer detrimental treatment, you will be, you are in a very strong position because you have protection on that basis. And quite often when there hasn't been a finding on the basis of a complaint in chambers, the initial complaint, whether it's discrimination or harassment, there has been a finding subsequently of victimization. But on one other note I wanted to mention is something that I'm very keen on chambers developing is codes of behavior and kind of being on the front foot. And I think that I would want to see, leading chambers, all sets, in fact, but certainly led by those who see themselves as leading chambers, to have very clear codes of behavior that are enforced. So, if you want to be part of this chambers, these are the behaviors that we expect. And if you don't conform to these behaviors, then, we will be taking action. So you create a culture within chambers of calling it out, and that takes senior leadership. And that's not an easy thing. It's not for the most junior members of chambers to be leading on this. And I think this is a real area where we have to make some progress at the bar, because it's just, people seem to forget. They become senior, they don't experience the behaviors anymore, and they think that they don't happen anymore. They do happen. They happen all the time. We know that.
Thanks so much for that. I hope and think I've covered everything other than BSB routes. Now I'm going to turn to Adriana and Mark to give us some information about the dreaded BSB and complaints that go through there. I really want us to cover so many points in respect of this, because I think for many barristers, this is an arena that's an absolute mystery. I know for me, it's an absolute mystery. So I'd quite like to dispel the myths of what happens there. That will include things like what is serious misconduct? What kind of behavior breaches the code of conduct when we're talking about things like bullying, harassment, discrimination? How are complaints dealt with? What are the stages? Mark, Adriana, whoever wants to start first, please go ahead.
Well, shall I start? I mean, first of all, I do very much agree with what Sam and Elaine have said, that this is a cultural problem, and chambers and indeed employers are a big part of the solution. So alongside our disciplinary functions, we will in the year ahead be working with the profession to define our expectations of chambers and employers in this area. And I certainly agree that those expectations should encompass codes of behaviour, as Sam has mentioned, should encompass having somebody senior in the chambers taking responsibility for ensuring that there are processes in place in chambers to support people who make complaints about bullying and harassment. But having said that, this does engage the regulator as well. So let me kind of turn to your question, Natasha. The answer is that the code of conduct, the core duties include a duty that you must not discriminate against any person. So the answer, I think, to your question is, if you feel that you have been the victim of behaviour that discriminates, you should report it to the Bar Standards Board, or if you witness behaviour that you think discriminates, you should equally report it to the Bar Standards Board. Indeed, as we've been discussing, you're under a duty to do so.
Thank you so much for that. That's really interesting and helpful. I was just wondering if you could give us some information about how to make a complaint.
Yeah, I can take that one. So the reports actually come to my team, which is the contact and assessment team at the Bar Standards Board. And we're kind of used as like a triage system to look at all the incoming reports and decide where they go next. So we go through a very thorough risk assessment, which is, you can find our policy online. It's called ROD02. It might bore you, but it's there. That's how we assess our reports, and we look at potential breaches of the handbook. So in the information that you provide to us, we then go through that, and then through our risk assessment, pulling out the things that have been highlighted in these reports. And then at the end, we get a risk score that tells us what we're going to do with this. If it's about relatively low breach, we can write informally to barristers and tell them, you know, for example, quite often we write to them when they're holding out, when they're not authorised to do so. That would be seen as quite a low breach. Then amber and around there can go to our supervision team. So you can report chambers to us, and our supervision team do a lot of work with chambers. So if you have concerns about the way you're being treated by our chambers, we do want to know that too. It's not just other individuals at the bar. And then if the conduct is found to be really serious and a potential breach of our handbook, then we can refer that to the Legal and Enforcement Department, and then they will carry out an investigation from there. If there is no potential breach of the handbook, so there's no evidence at all from what we've been provided, then we will write to the information provider to tell them exactly why we're not taking further action. And the barrister will be given a copy of this report and the decision letter, so they know exactly why we're not taking any further action.
Okay, that's really interesting. So you sort of grade the complaints into 3 different sort of heat bands, as it were, a bit like a Nando's heat card.
Yeah, not too different. Yeah, there's 4 scales, and it's worked out very mathematically with different risk scores on different areas. It can be found in that policy if you really want to have a read. But yeah, that's how we decipher, and it tends to be we have to weigh the evidence and then the harms, the various harms, so harm to public confidence, harms to legal rights, and harm to the person. And then it goes against the weight, and then you get the risk score. But if there was no evidence in the first place, like we can't see anything from the report that would potentially be a breach, we would stop there and write with our dismissal reasons.
And at this stage, what kind of evidence would you be wanting for us to provide?
Well, that's a very good question. It depends. We would want anything that you feel supports your report. So this can be messages, it can be emails, it can be transcripts. We can't actually advise you what we want, but we would say attach anything you think is relevant. It really helps us to put together the whole report and understand exactly what's been going on in context. We can make further inquiries about things that we need. Potentially, sometimes we get transcripts, or if you have them, we might request them, or if there's information that we feel from the report isn't quite there, we may come back to either yourselves or the information providers and get that, so we can make a thorough assessment based on all the information we need.
Does the information need to be formal? So, for example, I'm thinking of an example of, say, someone was behaving inappropriately towards me, obviously a barrister. I have another barrister who witnessed it. Would I need to get them to draft a formal witness statement to attach that to my complaint? No.
Not at this point. So at this point, we want you to just report it to us, and we don't ask you to use like any legal language or quote parts of the handbook. We just want to know what has happened. So if you are able to put that down, and if in the report form, so we'd ask you if it's possible to go through the online report form, because that gives you spaces to tell us exactly what we need to be able to make that assessment. So there is a space in there where you can put potential people that you'd like us to contact as well. That's not necessarily picked by us in the assessment team, but that may be picked up with the enforcement team. So then if it goes over that to that side, they can contact, and the beginning of witness statements can be drawn and things like that. But for our stage, we don't need that necessarily. If we feel like we need it, we might write to you and ask, but we won't ask you for any formal statement, just what's happened in your own words, kind of thing.
Okay, brilliant. Thank you so much for that. And on the flip side, what happens if a complaint is made against you? What do you receive? What do you know? What are you asked for? Those sorts of things.
So if a report is made against you, if there is no potential breach, you will receive a letter either via email or post, depending on what your preferences that you've given to the Bar Standards Board. And it will be a copy of the report form from the information provider, and it will be a copy of our decision letter as to why we're not taking any further action. If you are a barrister who has reported another barrister, under your obligation to report to us, you will not receive a notification that you've either had a report made against you, or if it's gone any further at the assessment stage. If it goes over to enforcement, you will be notified. But if there's no potential breach in the assessment stage, we don't let the barristers know. So to encourage like candor reporting, but we do use that information overall to put together, like similar to the Bar Council, a picture, and we can alter our regulatory responses to those things that we see keep occurring. But yes, you'll know if it's been by a member of the public, if we've dismissed it at the assessment stage. If it's by another barrister, you won't usually know. A self-report, we will let you know. If it goes over to the enforcement team, they will contact you at some point to either get your statement or put forward the allegations. I can't really speak as well on that side because I don't work in that team, but at some point down the line, unless it's been made by a barrister, you will find out.
Interesting. And in terms of this assessment stage, how long does it take?
We have a KPI of 40 working days, so that's 8 weeks. Sometimes we can turn them around much quicker. Sometimes it can go on much longer. It really depends, again, on the circumstances. So if there's ongoing legal proceedings, we put our assessment on hold so as to not interfere. If we're chasing courts for transcripts, that can take some time. So it really does depend, but most of them, the majority, do get turned around in 40 working days.
Interesting, thank you. Sorry, the reason why, I don't know if my face, my horror was visible or not visible, but like, I think I've mentioned this before. I'm really scared of the BSB. I'm really scared of complaints, and the idea of like 2 months, I was just like just waiting for 2 months to hear what's happening, if we knew about it or whatever. Okay, brilliant. So
Natasha, can I just add one thing? I think what's really interesting is quite often when I get barristers who call me up and they are facing discrimination, or they've been facing difficult treatment, that they're highly emotional, and it's it's when it happens to you, it's horrible. Your self-confidence is destroyed, etc. It's always really interesting that very, very rarely have they written down what's happened to them, or have they done a chronology. And quite often I would say, what would you advise a client if they came to you to do in these circumstances? And people are because people it's such an attack on your personal, on everything, your professionalism, your everything about you. You forget the kind of obvious ABCs: keeping a record, making a note, knowing when events have happened, if it's a series of events. I mean, that's where Spot can be helpful in creating records. So you've got these personal records of incidents, and then maybe you need several incidents before you make a complaint. And I think the Spot reports can be submitted to the BSB as well as part of that kind of evidence pack. But it really struck me when Ariane has talked about the kind of your evidence is so often people are not thinking about that when they are facing discrimination or harassment and bullying. But it's really important to think about what you'd advise somebody else to do as well.
Very much agree.
Thank you for that. Elaine, did you want to add something?
Yeah, I just wanted to clarify something, but it's right though that Talk to Spot would never automatically trigger something with the BSB. It would never do that, would it, Sam?
No, sorry. What I meant was if you created personal records with Talk to Spot, so these PDFs that could be sent to you, you could then, if you could then choose to email them directly to the BSB, but certainly it would not go via Talk to Spot. Sorry if I made that unclear.
No, it's just that I know that from previous discussions, some people are a little bit confused about what Talk to Spot does, and some think that potentially it can do that. So I think it's good to clarify it. And I also saw a comment about having a video on Talk to Spot and how it works. That might be a good idea to consider.
Yeah, I've made a note of that.
Oh, good.
That'll come.
No, thank you for that. That's really interesting. I think it's good for people to know, because I think from what I've heard, just around about, on the streets, I'm not on the streets. I mean, it's a pandemic, but what I've heard is that a lot of people have been concerned about who sees what we put in Talk to Spot, what happens to it afterwards. Does it end up being something that gets taken out of our control, especially given the fact that we as barristers sort of have a duty to report. I think we're sort of worried that if we put something in Talk to Spot, it might end up triggering something along those lines. But I guess one good thing about speaking to the Bar Council, speaking to you, Sam, in particular, either on the phone or using Talk to Spot, is that you are not regulated. So therefore, I guess you do not have a duty or an obligation to report that, say, we as barristers might do if we get someone coming to us telling us that something has happened, that's serious misconduct. So I think that's another reason why we should be calling your line. And I'm sorry if after this event, you're going to spend your entire days for the rest of your time at the Bar Council just answering the phone every 2 seconds. But
what I'm here for.
Good. Now, I was wondering whether the BSB understands, considers, agrees with the concept of vexatious complaints, where somebody may be making a complaint, not just for the fact that they feel that behavior needs a complaint because of what it is, but that they're using the mechanism of making complaints as a tool to bully, harass, intimidate barristers. Is this something that the BSB considers when they're looking at complaints? Is there anything that they do about it? Or am I just speaking and you're looking at me like, no, I don't know, we don't do anything?
No, we certainly do consider it. Ariana may want to say a little bit more. I should say at once, though, Natasha, that our first reaction to a complaint about bullying or harassment is not going to be, is this vexatious? But clearly, as part of the triaging process, if we have reason to believe that something is vexatious, then we may look at that. But Ariana, do you want to add to that?
Yeah, so within our system, we can see how many reports are made by the information provider and about barristers. So when we see that the same person is raising the same report about the same barrister over and over, we can put restrictions on them. And we will write to them and tell them that we're not going to look at their reports because this has previously been raised and we've already made a decision on this. And that we won't assess their reports any further unless new information is provided. So we do keep an eye on this. We do have this now and again, but it is something we do take seriously because we know it can also, getting a letter from your regulator isn't the nicest of things. And a lot of people have said, when they see the BSB email or the BSB letterhead, it just puts the fear of God into the I'm seeing that there. And so, we don't want to cause unnecessary harm. And when we have these people, we do put the restrictions in place. So yes, we do take them very seriously.
Letterhead from the BSB is up there with those brown envelopes from HMRC at time periods when you don't expect them. They're things you do not want to see. We've spoken a bit about the assessment stage. I really want to hear more about the enforcement stage now. And I don't know whether, I know, Ariana, that's not part of your remit, but Mark, whether you can sort of talk to us about what happens then. And I also want to know at what stage we would need legal representation. I'm assuming that's going to sort of slide into James's area, but If you could talk to us about what happens at the enforcement stage. What do we get told?
Yes.
If the complainant or informant, I can't remember what you call them, or if we're the person who's has the complaint against us, what happens?
So we're at the stage that Arianna has described. We've come to the conclusion after looking at a report that there is some evidence of a breach of the code. We will then refer it on to an investigation, which is taken forward by another part of the organisation. And the results of that investigation, if that also concludes that there are grounds for thinking that the code of conduct has been breached, will then refer the case to our independent decision-making body, one of the panels of our independent decision-making body. And as its name implies, that's a check and a balance on the executive in the Bar Standards Board. So panels composed partly of lay people and partly of barristers, but completely independent of the Bar Standards Board, who will look at the results of the investigation and decide what to do. They may decide that the case should go no further. They may decide that an administrative sanction of fine is appropriate, or they may decide that disciplinary action should follow and that the case should be referred to BTAS, to a disciplinary tribunal. Now, it's entirely up to a barrister against whom a report has been made and where an investigation is taking place, whether he or she seeks legal advice and retains their own counsel. That's a decision for individual barristers to take. Many do, and I imagine almost all would do so if a case came before BTAS and a tribunal. But James is probably best placed to pick up the story from there.
Before we move on to that, though, I do have some questions about the investigation. I really want to know, like, what happens. Are you guys like the police of the bar? Are you there sort of like taking statements? Are you going to the court and being like, we want the CCTV of the outside of the courtroom where a barrister slaps someone on the arse? That sort of stuff. Like, are you really going in on it? Or is it literally just you emailing the person who's made the complaint? Could you just tell us a bit more, please? Thanks. Like, how much do you do?
No, Natasha, an investigation is what it says it is on the tin. It is an investigation, so the investigators will look at all the evidence that's relevant to the report. So it might include all of the things you've described if they're relevant, and that all that evidence will then be put in front of an independent decision-making body panel for them to take a decision on what should happen to the case.
And if you decide to do anything other than push it through to BTAS, if I were to be the person that made the complaint, do I have a right to appeal that decision at all?
You can challenge the process at any stage, Natasha. Yes, but clearly. The decision is ultimately made by the independent decision-making body panel about whether the case should go no further or be referred on to BTAS.
And I assume, would it be at the assessment stage or the information stage that the person who has a complaint made against them gets to have a right to reply or something?
As part of the investigation, the barrister against whom the complaint or the report is made would be given the opportunity to state his or her side of the case. Absolutely, yes. Okay,
brilliant. And how long does that stage take, roughly?
Oh, that varies a lot, Natasha, I'm afraid, and it depends quite a lot on whether the barrister concerned does challenge the process as it's taken forward. We would aim to complete an investigation in 6 months, but I'm afraid some investigations do take longer.
And maybe this one is perhaps maybe for Elaine or Sam or possibly James. If we were to want some legal advice at this stage, would it be covered by Bar Mutual? Do we know?
I think that's right. I think that's right. I think from an early stage, you can approach Bar Mutual just for a conversation. They will let you speak to one of their solicitors. Even if there's not a formal complaint yet, maybe it could be an informal complaint that's been made, say, by a client within Chambers, you can then approach Bar Mutual. They're usually very helpful to refer you to solicitors. It could be 5-minute conversation, simple as that. So as I understand it, there is quite a flexible approach there.
That's good. I'm smiling in part because I know how much I paid them, so I'm glad that they will be there to help.
You hope to use them as well.
That's the thing about insurance, you pay for it hoping that you'll never ever need to use it.
I was going to say, many years ago, I used to be on that panel that Mark referred to as a barrister member of the complaints committee. And one thing that I do remember is that if there is an investigation, it's certainly in your interest to respond and to cooperate as someone, where there's a complaint made against you. Because if you don't respond or cooperate, that can be seen as negative. And you aren't going to be doing yourself justice if you're not doing that. So certainly one of the things that I remember being discussed when I used to be doing that role before I shifted across to the Bar Council.
Thank you. That was really interesting. I just feel like I'm just learning so much about a world that I don't know, and I'm hoping I'll never actually need to know, but in a personal capacity. If we could just move on to James, and if we could first off start off by you, James. And by the way, everybody, James used to teach me at Kaplan when I was doing the bar course. So, it's been, 10 years now? Oh my gosh, since then. But James, if you could first off start by telling us what BTAS is, because I think a lot of people might not know what BTAS is and what your role is.
I don't want to, Natasha. I want to start with an advert, if I may.
Okay, go ahead.
We are currently recruiting for new panel members of BTAS and for clerks to BTAS. And this is the solution to all of your worries, Natasha. Become a panel member or a clerk, and then you'll understand the whole process and it'll become demystified, and it'll be fantastic. We really, really, really want people to apply to become panel members. And you'll know all the reasons why. The broader the spectrum of people that are on the panel, the better the panels will be. And I could bleat on for hours. So please have a look at our website, Google Bar Tribunal and Adjudication Service, and you'll see the roles being advertised. They're paid at a daily rate. And really, really good for your CVs and for your careers, and particularly if you want to sort of broaden to regulatory law and so on and so forth. It's an excellent opportunity, so please do apply. But I'll put that aside and now do exactly what Natasha says. So BTAS. BTAS is an independent body. We're set, so just so you know, we're set up under a service agreement with the Bar Standards Board. So, how well we run tribunals and so on. But beyond that, we are not in the pocket of the Bar Standards Board, and that's not what they want, and that's not what we want. And so our role is to run a building which has tribunal rooms in it, to recruit and appoint and train panelists, both lay panelists and barrister panelists and judicial panelists to sit on the hearings, and then to run the processes that will, in a sense, take it through from the first time we hear about a matter through to final determination, and if it's been found there is professional misconduct, to sanction. So that's what we do. It's paid for by the Inns of Court, and the Inns do it because it's one area they don't want the costs of running the service to fall upon the individual members of the profession. So the Inns fund that. And it costs them about $500,000 a year to run that. So that's what we do. And so Natasha getting her revenge on me being her tutor years ago, when I used to ask her lots of questions, set me about 12 questions to answer. And so you've got to see how I do, Natasha, and tell me whether I get her a very competent or whatever. Yeah, so what happens is that we will receive from the Bar Standards Board a notification that if you like, a matter is coming our way, and from that kicks off directions and a convening order process. I suppose the big message I want to give is that yes, it is a formal tribunal process as you would expect it to be, but we like to think there's nothing in there that a barrister is going to be surprised about. That they're normal processes, and I know that when you're the person involved in it, everything takes on a different hue, but it's pretty standard stuff. So information comes through, and that will trigger processes where we are getting in touch with you, both parties, that is, for information where there might be the standard directions of the norm, and we're looking at all the stuff that you'd expect about listing and documents and witnesses and witness statements, and getting everything queued up, ready for a hearing, skeleton arguments, bundles, again, the usual fare. If that isn't agreed between the parties, and often it is, but often it isn't, then there'll be a directions judge who will kind of decide whether, you know, X witnesses are allowed or not, and the whole usual process. And then there'll come the day when the hearing actually takes place. And again, you could be there in any capacity. You could be there as a panel member, as a clerk, acting on behalf of somebody, or indeed as a respondent. And it's the usual setup that, you know, the 3 or the 5 people who are on the panel will come in the room and everybody will stand up, and then they sit down, everybody sits down, and then the hearing gets going, and we'll go through that process you would expect. The BSB opens and presents, well, there's preliminary matters and so on, but then the BSB opens and presents their case and brings their witnesses. There may be a half-time submission of no case or something, but then it switches and the respondent presents their evidence, and then there are closing submissions. The panel retire. The panel will be a 3-person panel if it's potential for there to be 12 months or more suspension or disbarment. Sorry, if it's less than 12 months suspension at large. It'd be a 5-person panel if it's more than that. They'll come back and they will you know, say what the outcome is of the finding of misconduct, and then move on to sanctioning, hearing representations on sanctioning if that's appropriate. So that's broadly the process.
Thank you so much. I have previously practiced in professional discipline, although not hearings in front of BTAS. I think that would scare the life out of me because.
Oh, then you must apply then. Go on.
You know, I can't. I'm a member of the Bar Council, so you guys don't have me. I know. I think I have to wait, what, a few years after I step down? 2? Okay. Well, maybe you'll see me in like 2 or 3 years' time. But yeah, so I know that when it comes to like professional discipline matters, different tribunals follow different rules in terms of like, you know, the standard of proof, that sort of thing. So I was just wondering, what is the burden and standard of proof in BTAS?
Yeah, so the burden's always on the BSB, unless there's kind of legal technicalities about reverse burdens and boring stuff that I couldn't comment on at this moment. But fundamentally, that is for the BSB to establish. The burden changed. It's for matters that arose before April 2019. It was the criminal standard. But since 2019, in essence, bring it into line with pretty much every professional regulator. It's now the civil standard. The rules of evidence are very akin to the civil rules of evidence, so anything can come in, and it's for the and there can be representations on this, but it's for the panel to determine what's relevant, and if it's relevant, whether what weight they will put on matters, but generally they don't exclude evidence. The main basis really for excluding evidence is if it's hearsay evidence, which is generally admissible, but hearsay evidence, and there's no good reason why the direct evidence wasn't brought, or better evidence wasn't brought. So if it's kind of laziness, for want of a better phrase, then they may exclude it on that basis. But generally it's civil type processes, and the hearings will be in public generally for the reasons of transparency, etc. But there can be applications from any participant for the whole thing to be in private, or for elements to be in private, for a particular witness to be in private, or a particular element of a witness statement in private. So there's a presumption of public, but, you know, for moments, and it's that balancing act about, you know, is the sensitive information about the complainant versus a need for it to be in public will be dealt with, but they'll try and keep as much in public as possible. Okay.
And do you have like special measures for witnesses or complainants?
Yeah, for any participant, and even for the respondent as well. And again, in virtue will do anything that helps a fair hearing. And so we have very much in mind both sort of disability side angle on things, but also vulnerable witness, the full, you know, plethora of vulnerable witness type needs. So that might be from pre-hearing visits to the tribunal by anybody who wants to come and look around the building and see what it looks like. Having a named BTAS staff contact, if that helps. We're not a party, and so there's a limited amount we can do, but if it helps to come and meet somebody and just get to know them before you come, just as someone to help familiarize yourself, that's fine. Video links, screens, interpreters, regular breaks, hearing part of the evidence in public or private, as I say, supporters sitting with witnesses. And again, the parties between them may agree that, and sometimes they may they may not want something to happen, and it becomes, in a sense, legal argument over certain elements. But in terms of the tribunal service, we will provide all the things that we can provide to make what is a difficult situation as easy or straightforward as possible.
Okay, so if we move on to the stage of misconduct being proved, could you just give us an overview of the type of sanctions that can be passed? And then also, I know that you've published a new sanctions guidance. If you could sort of give us a run through of the changes that have happened in that.
Yeah, so again, if you go into the BTAS website, you'll see that there is a sanctions guidance. And thanks to the Black Barristers Network, we consulted on it last year, and I virtually lost a year of my life rewriting this sanctions guidance. But we had lots and lots and lots of responses and lots of useful comments and really detailed responses, which was incredibly helpful. And so what happens is that the panel will then work through a process that's set out in the sanctions guidance, which will be familiar for those in the criminal world, practicing the criminal world. So it's similar to the Sentencing Council guidance, though not the same. And so they'll identify the relevant form of misconduct, sexual misconduct, harassment, dishonesty, whatever, or different forms that they have to kind of triangulate it off against. And that will then have guides as to things to take into account and ranges of sanctions for those things. They'll take a seriousness look of things, so that doing a culpability harm sort of balance. And then they'll pitch it with an initial point within a sanctions range. And then having done that, take into account aggravating and mitigating features, which may bring the matter up and down within the usual range. Then look at totality. So if there are a number of charges that have been proven, they'll bring them together and think, okay, as a whole, how should we sanction here? So yeah, as you said, Natasha, that changed from the 1st of January this year, and that we brought in new guidance. So that we brought in that much more structured approach, that methodology. So that 5 or 6 steps. But also we took a long, hard look and the subject matter of a lot of the consultations on what are the appropriate sanctions for certain matters. And the 2 in particular that I'll mention, which garnered a lot of attention, were sexual misconduct and discrimination. And really, I think it was overdue that those sanctions needed looking at. So sexual misconduct and discrimination, the lower end of the ranges were starting at reprimands and medium level fines, which can be as low as £1,000. And that did result in some criticism. So that has moved dramatically, shall we say, and now the lower end of the range, if there's a finding of professional misconduct involving sexual misconduct or discrimination, is starting with 12-month suspension, going up through to disbarment. And anybody will know that 12-month suspension is a serious sanction against somebody's practice. Now, if there is aggravating and mitigating or culpability harm factors that bring it down below the 12-month suspension, I mean, the panels all have, in all these circumstances, complete discretion that it's only guidance. But if they go outside of the normal ranges, they have to explicitly say why they're going outside of that range, why they're going below the norm, and so on. But the lower end of the guidance is now much higher than it was.
Thank you so much for that. And I know the Black Barristers Network responded to the consultations, and we're grateful that you listened to us because the sanctions have been a massive concern for, well, the previous sanctions have been a massive concern for both Black barristers, women barristers, and, as you can imagine, Black female barristers in particular. So I'm glad that those have increased significantly. And I think it shows that the bar as a whole takes that sort of behavior seriously.
Absolutely, I agree. Yeah.
So I'm grateful to everybody for that. And just a side note, I assume that if misconduct is found against the sanctions, but there's also costs that we may have to pay. Is that correct?
Yeah. So so again, we don't charge for the cost of running the tribunal itself, but it is the cost of the parties. And so before the proceedings, the respondent will ask to fill out means forms. That's really relating particularly to fines. So the fines are dealt with first, and then any cost matters are dealt with after that. Cost is not a sanction. So in a sense, it's not a sanction matter, but either party can make an application for costs, and they will make submissions upon that.
Thank you so much for that, James. I think, unless anybody has anything to add in respect to the BTAS, any comments anyone wants to make in respect of that end of it?
I do.
Yay.
Please apply 4th of April. 4th of April, I want your applications in, please, to become a panel member, okay? Because it's really, really important.
It sounds like it would be an excellent experience as well.
It really is, yeah, because you get the opportunity. Sorry, I'm going to go on a bit. If you're, a practitioner, you get the opportunity to sit in sort of a judicial function and see that going on, and it's really, really good for the CV, and it's just important, and it's an income stream, and it's fascinating as well. And it's fascinating watching your colleagues who have been other members of the bar who have been, accused of these things, and they're in a very vulnerable position, and they need that fair hearing. So do it. 4th of April deadline. Okay.
Brilliant. Thank you so much for that. And yes, do everybody apply. I think it's really important for us to have balanced panels when it comes to these things, including in terms of race, for example. So I would really encourage everybody to consider applying. We need to get some more ethnicity on those panels. Okay.
Free tea and coffee and biscuits as well.
That's exciting.
I don't think what other reasons there are to apply. Travel expenses. You get to meet me a lot. So
he's great. I loved his classes at bar school, if that helps. Okay. So if we move on to the general Q&A, I'm going to start off with some questions that we received previously that I haven't already asked as we've been going along. And then I've seen some questions have been posted whilst the talk's been going on. And if anybody has any questions that they want to put into the chat on YouTube, then feel free. They're going to be passed over to us and we'll be able to answer them. One question that we got in advance was how to deal with harassment and bullying from a client, particularly from a client who may be sexist and may indeed be the same race as you or different race. I think, James, you were happy to start with this one.
Yeah, I mean, my view is, is that, it's again a bit like a thing that I was saying earlier. It's important to name it and shame it with the client, and in a sense, give them a chance to, to amend their ways, for want of a better phrase. But I think ultimately, and all these things are matters of degree. If it is of a particularly, abhorrent degree for you, as it were, then I think you're within your rights to withdraw. I don't think anybody in any position should be obliged to work under conditions where you are being discriminated against in that way. So that would be my view. And I think if it's really extreme, you can withdraw and, in a sense, leave them to their own devices. I don't think you have to represent somebody under any circumstances in that way. And my view is that would not be a breach of the rules, but others may differ.
Mark, do you have anything to add in respect to that?
No, Natasha, I very much agree with what James has said. These are cultural matters, and we won't change the culture if people, just grin and bear it. So I think it is absolutely right to push back, and we would certainly, not regard a barrister as in breach of his or her duties if they had been the victims of discrimination.
Sam?
I just wanted to add a really interesting one, because I'd be interested in James and Mark's view on this. And this is where we had a complaint from a barrister who was facing foul racist discrimination from a litigant in person on the other side, and that was, what can be done about that was the was what we were asked.
My response would be not to engage with them personally outside of the courtroom. I'd say to them, well, look, we can't talk anymore. I'm not taking this. In a sense, I'll see you. Let's get in front of the judge, and then I'd be sort of looking the judge to take charge of the courtroom. That's how I do it.
Yeah, no, I agree with James. It's probably worth saying, as Arianna can probably confirm, we do get quite a lot of reports from litigants in person, and very often they are based on misconceptions about the role of the barrister on the other side. Not, I think, very many of them, I'm glad to say, involve foul racist abuse, but litigants in person very often do misunderstand that it's the role of the barrister on the other side to put the opposing case.
I was going to echo to take it to the judge, and I remember years ago being quite a junior barrister after winning a case where the litigant person had been accused of being violent. He threatened to decapitate the CEO of a charity that was the main witness, and we had to go back in front of the judge, and he dealt with it by getting security. I mean, if there's if you're in the thick end of it, you need to go back in front of the judge so that it can be dealt with.
One thing I would ask, though, is if, for example, because we're talking about going back to the judge here, a client said something towards me that was inappropriate, would we be breaching confidentiality if we were to go to the judge in respect of it?
Oh, I'll have a go. I don't mind being the first to have a go to get it wrong. If it's your own client, so the last scenario was against a litigant in person. If it's your own client, yeah, you've got to be respectful of that. And I think ultimately that's where it's frank chats, and you maybe get to the point where you're embarrassed and have to withdraw. I think what's happened in those frank chats, I'd be very reluctant to disclose to the court. Well, you shouldn't. But you may have to walk away and just go into the court and sort of withdraw formally, and off you go.
Thank you so much for that. I've got a different question now, and I think it's from the perspective of chambers. What advice would you give to chambers wanting to create a safe space for individuals to raise concerns about racism, bullying, or harassment? I don't know if Elaine or Sam want to come in with respect to that.
I think the starting point is to make sure that there are clear, transparent procedures, that everyone knows where they are and who is running them in chambers, and how to make a complaint. And also, again, going back to knowing who the EDOs are, who the Equality Diversity Officers are, so that you could actually discuss it in that safe space. Because initially, it does depend on the facts and the circumstances. You don't necessarily know yourself if something has been transgressed to a certain extent. So having that opportunity to talk it through with someone in a supportive way, I think is coming close to that safe space. So I think clear, open procedures and it being clearly signposted within chambers where you can go to and what those procedures are.
I think you have to keep messaging it as well. This is where heads of chambers, that's senior members of chambers, need to take a lead in setting the culture within chambers, and the sort of going back to my sort of codes of behavior, standards of behavior, what is and isn't acceptable. And I think people are very quick to see if a chambers has got all the greatest policies and processes in the world, but actually doesn't implement them in any way, and it's not authentic. So again, I think it's the onus is on chambers to be authentic. If it says it's going to deal with these issues properly, then it needs to. But I think I put in the chat, one of the problems that many organizations will face, is that, you know, with the complaint, the confidentiality associated to complaint, you can't always say what you've done, what the outcome has been. And there's a degree to which we have to have faith that a system is working, because, you know, you can't always know everything, who said what to whom, and what you know, even if it's an informal complaint, you know, sometimes these things are dealt with, but you can't be told about it. And then we're in that sort of catch-22. If you're not told about it, you think it's not happening, or it's not happening properly. So I think that's a bit of a challenge. Sorry, that was a bit of an aside on my leadership taking a stand.
Another question that we have, and we've had it said in two ways, so I'll try and sort of amalgamate it into one. What do you do when a person is reluctant to make a formal complaint? The other question is, if a junior member of Chambers tells you about unacceptable behaviour but doesn't want you to say anything about it, how do you balance confidentiality with wanting to ensure the behaviour stops? What do you do if someone comes to you with a complaint, with an issue, tells you about it, but then does not want you to take it further? Does anyone want to do it? I'm just trying to think. There's the regulatory perspective. There is the fact that, you know, is it serious misconduct? Is it not? Do we have a duty to report regardless? I think is a question. But then also there's the more pastoral support sort of question within it. So perhaps maybe if we start with Mark, if you could tell us, I know we have our duty to report serious misconduct. How will we know whether or not it's serious misconduct?
Well, look, I don't want to be glib, Natasha, but, you know, it comes back to the code of conduct, and particularly the core duties. So if what's been, you know, reported to you seems to you to breach the core duty not to discriminate against another barrister, or indeed a clerk or a client, then the duty is engaged to report that to the Bar Standards Board. And it clearly should be reported. And
that would override, I mean, you wouldn't really have a duty of confidentiality to somebody that's telling you wouldn't. So I'm just sort of going by the wording of the question, you wouldn't. So even if you had a personal moral obligation, it sort of overrides that. You have to make the complaint.
Yes.
Yes, and James, you unmuted yourself, so I assume you have something to say about this.
I have lots to say. I mean, it's a really tricky one, and it's something we've stared at over the years. But as the rules stand, I think I would take the conversation along the lines of, you know, if somebody says, I really need to talk something through with you, I would give that kind of warning at the beginning. I know that's not always how things happen, but if you can, and say, look, if you tell me certain things, I might be on obligation, even if you don't want me to have to report it. Then bends the rules. And if you're concerned about that, and you want to talk to somebody without that being at risk, then phone Sam Mercer, phone the Bar Council, and have a chat with them first. But you know, we've tried various schemes over the years of trying to have some individual named barristers who can sort of, and Sam can comment on this, I'm slightly lost track of where we've got with it, be named per people you can go and speak to without engaging the obligation, but they've never really got the kind of come together in the way that's useful. So I think if you're the person receiving, you know, getting somebody's coming to you to say, I want to talk something through, you've got to come up front and say, be careful, in a sense, be careful what you say to me. I support what you can, but you might trigger another obligation. So, you know, be wary of that.
I think this is one of the biggest problems with this, particularly harassment and bullying. You know, it's the power dynamic, which relies on the person who is the weaker in that power dynamic. All the onus is on them, all the risk is on them to make that report and face the kind of repercussions of making that report. And I can't sugarcoat that. It's, you know, that's the system. You know, the number of times I've been told of people where somebody doesn't want to make a complaint. Unless they make a complaint, action can't be taken the way that the system is set up. And it's incredibly frustrating, because it means that we are stymied on taking action. So we kind of need we need members of the bar to come forward, and to change the culture, we need those people to come forward, and we need to throw all the possible support that we can at them. And I know from speaking to my colleagues in the BSB that certainly where somebody is a victim of harassment, they are given, they're allocated a caseworker who keeps them informed. Sorry, I'm speaking for you, Ariana, but I'm just doing a bit of your job for you, I guess, and just sort of saying, that from my side, Bar Council side, we have counsellors, we have access to help. One of the first things I will say is, have you seen your GP? Because it's incredibly stressful pursuing a complaint, and I know that. The BSB know that, BTAS know that, and so we're all there to support and make the process as painless as it can be. But I can't lie, there is going to be pain involved in it. But unless we all take action here, we're never going to change the culture.
Yeah, just going off what Sam said there, like, do talk to us. We're not as scary as I think, we have a reputation for. And before you make reports, you can talk to us about the process. If you want to find out what's, could happen along the line of the assessment process to go into the enforcement stage, then we can talk to you about this before you make any form of report. As soon as you make a call to the BSB, we haven't locked you in, you aren't there to make a report, and you're stuck in it there. You can talk to us and find out the information you need to be able to make that report and come to the decision if you want to make it yourself. And like Sam said, when it is harassment cases, you get a named person in each team, and we really do take these very seriously. And even when the reports don't go through, I'd still say please do report, because we can build a picture, we can understand what's going on at the bar. And especially, say for example, with the same behaviours coming up at the same chambers a number of times, that can go to our supervision team and they can do things with chambers from there. So we do want to know about these things, and you can speak to us and we will explain the whole process to you, and we will take the time to do that, because we promise you we aren't as scary as many have out the regulator to be. So please, if there are any people considering, and we won't take action against a person who is a victim and doesn't report. So if it takes you years to come to us, we will not take action against you because it's taken 5 years, because we understand how difficult it actually is to come forward and make these reports. So please also take that into consideration. Time is not a factor if you are a victim in reporting.
Thank you for that. I sometimes think that if I see something out in the public domain, for example, that to my mind is inappropriate and I might want to make a complaint, I think to myself, what is that going to involve? How much time and effort is that going to take from me? So I wanted to give you guys an example of something. If I were to see something in the public domain, for example, a racist tweet being made by a barrister, what would be required of me? Would I have to give evidence? Would I have to be involved in the process at all, other than filling out the online form? I don't know if Ariana or Mark wants to jump in on that.
Shall I have a first go, and Ariana can join in? I think the answer is no. You wouldn't necessarily have to be involved, Natasha. We can take forward a report based on the tweet itself. If it's in the public domain, then that's all we need.
It's good to know that I can now be a keyboard warrior without having to worry that it'll take up too much of my personal time. We're going to wrap up soon, but I'm just hoping to just get through a last couple of questions. A couple of people have raised questions/comments about making complaints and whether that can exacerbate the problem, whether that can lead to some reputational damage on behalf of the person who's made the complaint. Will it make our lives worse? I know Sam's mentioned victimization in that. If we're going through and we've made a complaint against a barrister, for example, and during that complaints process, we've noticed certain things that are happening, which are, let's say, could be linked to us making a complaint. So let's say, for example, make a complaint about a barrister and suddenly some work drops out of our diary. Or we have other members of chambers passing comment about it. Oh, she's the one that sort of made the complaint, you know, avoid her, that sort of thing. What would we be able to do about that? And what support is out there for those people who've made complaints and their experience in that kind of conduct? Anyone? If the answer is there's nothing, then maybe we should think of something.
From the Equality Act, barristers are covered, and it's victimisation. So if it was connected to a protected characteristic, so if the original complaint was connected to one of the, you know, sex, race, disability, orientation, that sort of thing, religion, then there is protection to, if you subject someone to a detriment because they've taken a protected act under the Equality Act, then there's protection and in terms of bringing claim. So in theory there is that, and certainly the threat of that can often put people back in check, because as we know, sometimes there are tit for tat responses, even though people are fully aware that that is not allowed. So it's always a good idea to know that that is within your reach, that, you know, you are protected in terms of a complaint that certainly falls within the Equality Act protected characteristics. I do wonder if it might also be victimising conduct that's related to that might also fall within the BSB remit, actually. It sounds like it should do.
Yeah, that's conduct we'd want to know about, and we could, take regulatory action on that. So if that does happen, then please do report it to us.
I think I was going to say, sorry, just coming in on that, Natasha. I think it's incumbent upon all of us to kind of educate ourselves around the process, like this event tonight, understanding the process and just recognizing, you know, it's extremely rare that somebody would make a vexatious complaint, and it takes it takes a lot to make a complaint. I mean, most barristers are extremely robust. They're used to the kind of, you know, the rough and tumble of the profession. And I think if somebody feels strongly about something enough to have made a complaint, then respect needs to be given to the bravery of that individual for making that complaint. And people don't make complaints lightly. And I think it's very, very important that we all recognise that and support people who make complaints, because they're actually doing the right thing.
Yeah.
And that goes back to the culture, doesn't it? Like you said before, the statement of values, training within chambers, so people know what's expected of them. I think if you've got clear open procedures, you've got training in place, and you have a statement of values, ethos or conduct internally, that will go a long way, hopefully, to shifting the balance.
I also have a question leading on to that about confidentiality, because someone did ask about this affecting your reputation if you were to, say, make a complaint, for example. I understand from, you know, hearing reports about certain cases that sometimes the complainants' names are not mentioned. I think, if I'm correct. If I'm incorrect, then look at me, stare at me like you're wrong. We publish everything. Okay, brilliant. So what kind of cases does that sort of anonymity direction, as it were, apply to? That might be something of interest for people.
Yeah, so it's the law, if you bring a complaint, particularly in sexual misconduct cases, that you're entitled to anonymity. Not only your name not being reported, and to be honest, we've had to train ourselves to be better at this. Also, jigsaw facts, that various facts around who you are shouldn't lead to you being able to be identified. So I know that's the law in what we call sexual misconduct matters. I don't think it's actually the law in discrimination cases, but others could perhaps comment on that. But again, if that's a matter that's of concern to a complainant, then they can raise that with the BSB and ask for that to be dealt with within a hearing, regardless of whether that's strictly, if you like, right. Then it's something the tribunal panel will then be very, very sympathetic towards, considering when they write their reports is anonymising the complainant.
Thank you. And what training do the Bar Council, BSB and BTAS have on discrimination? If we start with the Bar Council, what training do you guys have on these sorts of issues?
With respect to the training that we have ourselves as members of a team, yes. Well, we would have ongoing training on equality and diversity and additional training on discrete aspects of the equality agenda. So where we're advising members of the bar on any topic that we're advising, if we haven't got the skills in-house, then we would train. We'd send members of staff on training courses, or they would work with members of the Equality and Diversity Committee to upskill on those areas.
Thank you. Does any of your training include anti-racist training?
Yeah, we've looked at anti-racist training and are constantly, like everybody else, looking to kind of develop skills and understanding in this area further. But I think particularly, as you know, with your support, Natasha, we've been involved in delivering race awareness training across the bar, and part of that includes anti-racist training and understanding of concepts like the key concepts within racism, and in particular gaslighting and all these types of issues, which I think is incredibly helpful, not just for all of us that have been developing this type of agenda, but also everybody who's participating in the training. And the training's had a really positive feedback so far.
Thank you. And Mark, what about the training that the staff that deal with complaints at the BSB have?
Yes, we did a survey of our people towards the end of 2020 to understand their experience of racism, Natasha, and that resulted in an anti-racist strategy and training. And we're also at the moment training all our people in drawing up equality impact assessments, where we take new regulatory interventions. Indeed, I think I'm going to do the training myself in the next few days. But Arianna, do you want to add to that?
Yeah, we also have our legal team who run regular trainings on things that pop up throughout the course of assessing reports and investigations, that they then deliver those. And we also, I'm a member of the Equality and Access to Justice team, and we also listen to what the members of staff are coming across in their day-to-day work and target training there. So recently we've run anti-Semitism training. We're looking at doing similar things. We're just finding people for it. So we're very clued up on what we want to do as training. We do have it quite regularly, and we do listen to the staff as to what they want, and we try to direct it where people feel they need it as well.
And James, what about BTAS and the panels?
Yeah, if you get your application in by the 4th of April, then before you're let loose on the public, what we've historically done is unconscious bias training and so on. What we're looking at now is extending that or broadening it to doing anti-racism training as well. Anybody who does selection of panelists, we have a whole team who they get training as well, and we have consultants that review all our policies and review all our training along the way. Natasha, I'm getting really hungry. Is it nearly time to go and get my dinner yet?
No, of course. I'm going to end this in a moment. I just wanted to say that I'm really pleased to hear that all of the various bodies that we've spoken about are receiving training in respect of these areas, in part because I think we, in particular as Black barristers, would be concerned that if we make a complaint about discrimination, for example, we'd want to know that you understand the experience that we've had and that it is discrimination, and then going forward throughout the complaints procedure that it will sort of be treated accordingly. Right, so I just want to say a very big massive thank you to everybody who is on this panel. Thank you so much for giving up your time and your extra time as well in respect of this event. It has been extremely helpful for me. I've learned a lot, and I'm sure everybody else has learned a lot as well. Is there any way in which, if members of the, I was about to say public generally, but barristers in particular, have questions for your bodies, is there like a contact form on each of your websites or anything like that where they can ask further questions? Yeah. Okay, brilliant. So do go on each individual website if you have any other questions about BTAS, including their recruitment, which I didn't realize I was advertising so much, and the BSB, and of course the Bar Council as well. Thank you so much. I've been Natasha Shatunde. Please enjoy your evenings. Hopefully, I'm going to try and upload this, or make sure it stays uploaded on the BBN YouTube page, so that you guys can watch it back, rewind, see my beautiful face again, see the beautiful face of the rest of the panel. And thank you so much again. Enjoy your afternoon. Thank you.